OKFM 101.7.
Na yenkoi na fe yene yewura Edudzi Tamakloe eni enkomo na enkomo no efa de ho efa Supreme Court ruling no eho matters arising law me moche
Gyakye anopa mejo so mecha wetu na
atifo nya joso na boko de
Gyakye obo ade ada roma bacho na won so
boko na asam nyina enie Supreme Court what the detailed reasons why or directly a parliament say yenyi owura Gyakye Quayson din emfiri a year enwumem sem na se bedwani a we represent as North. And by Joe, what king kind one more ruling no reasons in be?
Gyakye anopa once again mecha wetu phone na inti enra mensa eka ruling no 35 pages. A detailed analysis of it. Who say
by 35 the essential that knows be
now kind krana who say about 19 pages of it is basically a rehash of the facts, the submissions made by the plaintiff's lawyers, the lawyer for the first defendant, second defendant, and third. So 19 pages, all this, basically a rehash. Now, the analysis was within that 16 pages. Now, okay, the judgment, who say the Supreme Court essentially placed reliance on two decisions. Hello? Okay. Two decisions of the Supreme Court, or two earlier decisions of the Supreme Court. One, Professor Stephen Asare versus Attorney General. Any Senator Rawlings case. But what does it?
Mitiopa.
Professor Stephen Asare. And the case of expert senator. Now, may argue expert senator before the Supreme Court. And what was the issue in expert senator? In expert senator, Supreme Court can say, at the time, to me, I started not the end. I started questioning the eligibility or otherwise of a parliamentary aspirant a year when the EC opened nomination. But when the EC opens nomination, because in the specific case of Zanato, she had won the NDC primaries, awaiting for the 2016 general election. In between, and the closest opponents in the NDC primaries, Edike Sedebetiano say, our High Court say, on your registered voter pursuant to Article 94. I can say you should be a registered voter. But what I said.
Yes, me too.
Ekobasa. Now, Omomo country within the meaning of Article 94, she is not qualified. It made me raise a counter response to say, Supreme Court had decided earlier in the case of NDC, in fact, MPP versus NDC, in the year 2000, some chief directors became NDC parliamentary candidates in the MPP core court. Say, NDC no requires or failed those chief directors of ministries as their parliamentary candidates. the Supreme Court they can say the action is premature, among other issues. It may me raise that issue, say, at the NDC primaries, no, you can't be questioning those matters unless until EC has open nomination. And in the specific case of Zanato, since your only issue against her is that she's not a registered voter, the EC will be doing limited registration exercise before the 2016 election, by which reason she would have been registered.
Me too.
Which is entirely different. In any case, Zanato, the constitutional provision under contention in Zanato have nothing to do with the Gyakye Quayson matter. 2, the timeline now Zanato established here is completely different from the scenario that we are having here. What's the difference, Brother Kwame? First, aside Article 94, Ghana, Representation of the People's Law, PNDC Law 284, a statute. That statute is specific on parliamentary election contest. But what I say?
Me too, pa. So definite.
And only a specific. About parliamentary elections are aside Article 94. It could do Article 99. The next provision is the representation of the People's Law, specific to parliamentary election contest. Now, OSHA sections 20 of the representation of the People's Law now, a more specific timeline. The timeline, Emmanuel, or say, at the time of the person's election, OSHA, Andra, the Supreme Court appears to say, contrary to the express provision of the representation of the People's Law, the time for computation should be when the EC opens nomination and closes. Now, in taking this decision, Supreme Court Nankasa looking at any previous decision that were given in expert to Papa Kwesi into. But what case?
Kaipa.
Yeah. In the year 2016, Electoral Commission disqualified Papa Kwesi into.
Pa.
Into Papa Kwesi into Echo High Court. The High Court presided over by Justice Chebaford, as it then was. I can say, yes, Electoral Commission, who will 2 minutes be disqualified will be. However, because of the consequences of that disqualification, you should give the person a hearing. It's okay.
Yes.
Interestingly enough, my senior, I go to any guy requiring a yes, case. Into Electoral Commission after the High Court decision, and Supreme Court. Supreme Court presided by a panel. Into I know retirement so far in the trial, the decision of the Supreme Court in the do for Indum's matter. What was the Supreme Court that mean? Supreme Court I can say nomination period is continuous. It's not like an event. Nomination process includes the processes that allows the Electoral Commission to receive complaints, that allows the Electoral Commission to respond to the complaint, even give people a hearing before it takes a decision on their nomination.
Okay,
and to the extent that EC in Tusanamo, Ombe declared the Electoral Commission. The Electoral Commission now has to rope in Indum and go back into the contest. Okay.
Aye.
Good. Now, in this particular Gyakye Quayson way, obviously, I want to believe, sir, the court didn't advert its mind to the ex-party Papa Kwesi Ndum decision. Because, Okaya, in the specific case of Gyakye Quayson, the only reason why Supreme Court I can't say the election is unconstitutional. Only one. What is the reason? Almost say it's the OP nomination in October. But Gyakye Quayson had a certificate of organization in November. So because one certificate, in October, that's before EC open nomination or when the nomination was open. But on your certificate in November, no, it's unconstitutional. That is the only thing. Okay. Nothing more, nothing else. Now, juxtapose the reasoning of the Supreme Court to what happened in the Hindu matter, where the same Supreme Court say, to the extent say, Electoral Commission, to me say, obey me invite responses from nominees, and say, Bibi wa na nominee ni ya, obey me effective corrections, among other things. It is when that process is sealed, then you say the nomination has closed. Until then, you can't say that about the nomination process. Supreme Court understand the kind in 2016. To the point, he said, in the Gyakye Quayson matter, Okaya, now Krufobi was saying of from concerned citizens of Asenov. Some concerned citizens of Asenov, but what I say, Omwankasa call Electoral Commission District Director with a petition. Obviously, a MPP group. And no call say, Gyakye Quayson equa foreign nationality. Intima Electoral Commission a man who quine a man who contest. District Director no cancel petition no a too weighty. So no won't mean young Pontius Pilate or washing the hands of it. Intino or escalated. Now money be true. Yamami Mensa ho a one cry. Mensa so at a pound for say, Omunko share petition, no one share dear, where petition has merit or not. It's Electoral Commission Ankasa to inside every Gyakye Quayson say, Gyakye, bra. Petition in receiving against you, no. What says that? And also, Madam EC, Electoral Commission, my certificate in new.
I just sabe not what okutani certificate of.
Okay. Into Oko issue on also as early as 2019. But what I say?
You.
Me put an application before the Canadian authorities. And so, Masa at the passport, Canadian passport, at the application who they are common must say, Menemoto Quanta, Yapai. Yes.
I don't know, you know, I wouldn't Gary, Edim Como, Ewahano. One also resist say. We say we are not processing no end day. Even
only baby. You see, such statement now mean you are Gary Ekra Kano. With the greatest respect to your Supreme Court, rather exposes the judgment of the Supreme Court.
Why?
Because you see, because Gary is making reference to the laws of Canada and Supreme Court in can say, as far as our Evidence Act is concerned, foreign law is a question of fact. So if foreign law is a question of fact, it requires the assistance of someone to need evidence of Canadian law.
Oh, that is how it works.
Yes, that is how the law is. Bisagari. In fact, there's a recent Supreme Court decision now. Two of the judges on this Gyakye Quayson matter were on it. Justice Kulendi and Professor Mensah Bonsu. What happened? Sebio, Mano Dasunaso. But maybe I walk upon a bra, ewa broche, anya nesika, ayenioma. Ena ekoba say, Sebio, obema one no wono. Obema ne so on penubiu. Ena, mamino so anya japadie. Abrabono okobo ewo Italy no. Wanya ho japadie bebre. Afi papa no say, japadie na mamene di sika ba o de aye nyina no.
okayfm.
And you know his reason. Or say, Mammy, no, Italy, no, now, or 2-2, or a prostitute. And so, per Italian laws, no, prostitution is a crime. And you know, say the law is that you can't benefit from crime. What I say? Then the Supreme Court, the same Supreme Court, they can say, no. All throughout your case, you never raise the issue of Italian law. Because you know, say, Italian law is a question of facts. And factual matters must be proved. And you must prove a fact in dispute. So if you wanted to rely on Italian law on crime and prostitution, you should have led evidence. You cannot, at the tail end at the Supreme Court, now begin to introduce Italian law to deprive the woman of property that she had acquired. Because now Papa no can say, "Wo kura de 2-2 na oye wo Italy." And now the anya property ni nyina. It is Supreme Court men farmer no. And judge will say, now what also would be as a padena onya and they are proceeds of crime. Intima unbenefited from that. Oh, you want the same property for yourself? How is that going to be possible? What does it? But the points I'm making is say, and like Gary pointed out, and that for me exposes the loopholes in the Supreme Court judgment, because Ocean Constitution Article 94(2)(a), the Article 94(2)(a) can say you should not owe allegiance to a country other than Ghana. So in this case, the allegiance is not owned to Ghana; it's owned to where? Canada. Yes, sir.
Aye.
So if you want to do a fair analysis, then we should know what is the Canadian law on allegiance. And because the allegiance is owned to Canada and not you. If the allegiance is owned to Ghana, because already or a Ghana name by birth, so a natural. And yet the next layer, which is the alternative way now, Canada. No. So you need to receive the law on Canada. And Gary would agree with me, say, foreign law is a question of fact. And because it's a question of fact, evidence must be led as to Canadian law on allegiance. Because, the constitutional provision doesn't use the word in Article 94(2)(a), no, and using the word say, owes citizenship of another country. The word used there is allegiance.
okayfm.
So you can't tell me say allegiance is the same as citizenship, because citizenship is bigger than allegiance. In fact, Supreme Court Dankasakra rely on an Australian authority, Erred Carrigan, with the greatest respect.
But almost say, according to said that no any lawsuit etimu no, almost say who citizenship no, who your citizenship you must first hold an allegiance to that country for passport to the.
So in fact, the work can support me case. What it means there. Citizenship is bigger than allegiance. The incidence of citizenship is bigger than allegiance. What I say? So, Sebio, you are on my head of say Antwa Anakumeu. You see what you need. na wako anasante hini ho no wako swear the oath of allegiance to him ana does it take away the fact that ufi kumewu anantwa? It doesn't. The only thing that it does is that it shows say awesome nana anasikejwa kofi ana that's the only thing. And even our share allegiance is always voluntary.
Okay. Now, law.
No, black woman, me about take away. Me person mention why dream and to be so. Into which from the High Court to Supreme Court, who led evidence on Canadian citizenship or Canadian law on what shall I say? The Canadian law on allegiance. Was any evidence led?
No.
So how did the court come to the conclusion that at that material time he owed allegiance to Canada?
Okay. Law now, we know.
No. You see, Sebio, the law provides a platform for learning. And in most instances, even our judges have always said, say, look, they are fallible, they are human. And yet everything that they will know at a particular time. In fact, they relied on an Australian decision in Callaghan. Over that decision now, Australia has a particular provision on allegiance alone and citizenship. Clearly distinct. Is that the same law in Canada?
No.
So clearly, fairness would have required that the Canadian law on citizenship and allegiance is placed before the court. And you see, the Supreme Court, even in sitting in its original jurisdiction, has the power to receive evidence in order to do substantial justice. And you see, Black Kwame, this as enough matter. It's important that this matter is put out there. Look, at the High Court, my brother Gary will confirm. Gyakye Quayson can say, Article 94, a novel. So, yama ye Supreme Court, Emma interpretation of it. Meaning, Gary, you say, Dabi is clear and ambiguous. So the Supreme Court, the High Court can apply it. In fact, all kind of High Court decision as well. The High Court just said, Article 94 is clear and ambiguous. Gyakye Quayson go Supreme Court. Supreme Court said, the provision is clear and ambiguous. Pontius Pilate, and so on. And now Gyakye Quayson call Court of Appeal, Kipkus. Also raising this issue of constitutional interpretation. Once again, Gary said Dabi, Article 94(2)(a) is clear and ambiguous, so the Court of Appeal can apply it. In fact, Gyakye Quayson now went to the Supreme Court with a certiorari application. In that certiorari application, the Supreme Court again said decline jurisdiction by a 3-2 majority decision. Justice Poorman Edudzi dissenting said that be where the Court of Appeal can deal with it. Now, Brown Kwame, look at this. Curiously, the same lawyers who have opposed referral of Article 94(2)(a) to Supreme Court for interpretation, both at the High Court, Court of Appeal, of which the Supreme Court on 2 different occasions agreed with them. Suddenly, the same lawyer, the same plaintiff, issues a writ at the Supreme Court for interpretation of the same provision that they have said all along, say it is clear and unambiguous. You can't say, you just watch and allow it to go. Because on 2 different occasions, Gyakye Quayson was at the Supreme Court with certiorari application. On those 2 occasions, the Supreme Court said the provision is clear and unambiguous. Mekai said, Even in Justice Foreman's dissenting opinion, okay, say, he was on the Senator decision. This is Justice Foreman. He was on the Senator panel. And that in Senator, the Supreme Court never conceded Article 94(2)(a). In fact, Justice Foreman further went on to say, even the Supreme Court in Senator didn't look at Section 20 of the Representation of the People's Law. And so the decision in Senator did not lay like a rule of procedure or a rule on nomination. Anybody can read the Supreme Court 5-member panel when Gyakye Quayson went to the Supreme Court. Suddenly, by some miraculous way, the very lawyers who have opposed consistently any application for interpretation of Article 94 suddenly issues a writ at the Supreme Court. And in this case, the Supreme Court said, we have jurisdiction.
Now, law. Say, dear Namobeye.
As far as the laws of this country are concerned, the Supreme Court brings finality to the matter unless you go for a review. We have already put in Gyakye Quayson for the by-election. And like I told you, the only reason why the Supreme Court said his election was unconstitutional was that the nomination opened in October. He got his certificate in November. That was the only reason. The Electoral Commission statement about Bontino also obey open nomination 12th of June. And once you open nomination on the 12th of June, the man has a certificate of renunciation already. So he is deemed qualified. Obinekai, much ado about nothing. It is not like, you have found him that he had been.
But say, all right, so bet me a contested by election.
More than, because he has his certificate of renunciation already. And he got it as far as 2020. So what's constitutional by again? Are we not back to square one?
Okay.
No, that's what I mean. Are we not back to square one?
Square one. Okay.
We are back to square one.
Okay.
And save you, Mate, many MPP for no be say, Gyakye Quayson criminal trial no is revenge for second-day matter. So you are using the court for revenge.
Maybe comments are free, but first are sacred.
No. But most of their commentators have been saying. In fact, me ankasa mate, me ame senior Obi Buahin, me kura me no Adom TV on Saturday. Look, second-day's matter has nothing to do with Gyakye Quayson. Just for the record, because Rakwame, as far as the second-day matter is concerned, me person kai abusia for ya wewu. But the record will bear out that at that time, his lawyer Yoni Kulendi, who is now a Supreme Court judge, incidentally was on the Gyakye Quayson panel.
I see.
When make us so when during the trial there was an officer from Ghana Immigration Service who came to testify. At the time, second day, the MP who had 3 passports: Burkina Faso, UK, Ghana. Now get this correct. In the UK passport, he provided his place of birth as Burkina Faso. In the Burkina Faso passport, he provided his place of birth as Burkina Faso. In the Ghana passport, he provided a place of birth as Ghana. Even when he was an MP, he still had the 3 passports. But Kwame, how do you, for the sake of fairness, say, Obia or no, even before his election as MP, he had a certificate of renunciation is the same, if not for diabolics and mischief.
Now, medals are no pay.
Medals.
Medals pa. Yewura Godwin Edudzi Tamakloe. Wanu ye Edima John Dramani Mahama. Private legal practitioner and na twen komo na.
OKFM 101.7.